Hi, my name is Lee Heron. I'm a personal injury lawyer here in Florence, South Carolina, and the name of this video is What Happens? Now, I've been doing personal injury cases, mostly car accidents, for the past 15 years, and I want to give you a scenario, and I want you to tell me if you can figure out what would happen in this case. Now, you'll quickly find out that the reason I became a lawyer, one of the reasons, because I cannot draw. But what this is supposed to look like, this is a two-lane highway. And I want you to imagine a car going this way, and I want you to imagine another car going this way. And for some reason, they're both on their cell phones, and at the exact same time, they both veer over the center line and hit each other almost head on. So they hit each other on the corners here because they were both paying attention to their phone. They crossed the center line. Now I want you to imagine that this gentleman, he's an older guy, and as a result of this accident, he's got $50,000 in medical bills. $50,000 in medical bills. He's an older guy, and the other guy driving the other car, he didn't get hurt at all. Didn't even go to the emergency room. But this guy's got $50,000 in medical bills. He crossed the center line, the other guy crossed the center line at the same time. If we have to file a lawsuit in that case, if we're not able to get this guy's case settled with this guy's insurance company, and we had to file a lawsuit and it goes to a jury, what would a jury do with that case? What can a jury do with that case? Well, I want to tell you something about comparative negligence. Now, comparative negligence means what it sounds like. You ask a jury to compare the negligence of the parties. In some cases, there's nothing to compare. For example, if you're sitting at a stoplight and then somebody slams into the back of you, well, you didn't do anything wrong at all. You were just sitting at a stoplight and another guy slammed into the back of you. In that case, you would be 0% at fault. The other person would be 100% at fault. Obviously, that's not what we got in this case. We got to figure this out. I think we can all agree that this guy is 50% at fault and the other guy is 50% at fault because, again, they both crossed the center line at the exact same time. They both contributed to this accident. Now, if this guy just crossed the center line, this guy was in his lane, obviously that guy would be 100% at fault. But this is what we got in the situation. So what I would ask a jury to do is I would ask a jury to compare the negligence, and the jury would probably come back and say 50% for him, 50% for him. That's the kind of system we have in South Carolina, it's comparative negligence. Now in this situation, I'd ask the jury, if I was representing this guy, I'd ask the jury to pay my client's medical bills, and I would also ask the jury to give him pain and suffering, because this guy, let's say he's an older guy, and as a result of this accident, he has a herniated disc in his back now. So I'd ask the jury not only give him money for his medical bills, but pain and suffering. So let's just say that number came to $100,000. So I'd ask the jury to give my client $100,000. Now, some of you might say, well, wait a minute now. How can that be? Because this guy was half at fault. Well, here's how it works. What the judge would do is the judge would instruct the jury, and he would instruct them on comparative negligence. He would say, on this jury verdict form, I want you to write down the compensation you think the plaintiff's entitled to. Again, I would be representing the plaintiff because we'd have to sue the other driver. And I would ask them if they gave $100,000, the judge would say, okay, whatever number that you think the plaintiff's entitled to, whatever damages award, you write that number on the sheet. But also on that sheet, he'll have two blanks. And he'll say, I want you to allocate the responsibility for the accident to the drivers. So the jury would say, okay, we're going to find that guy 50% at fault, find that guy 50% at fault, and we give the plaintiff $100,000. So it'd be 50-50 and $100,000. Now what the judge would do after you came back with your jury verdict form is the judge would then take that $100,000, take the $100,000 you awarded, and then cut it in half. And the reason they would cut it in half is the judge would say, okay, you gave the plaintiff $100,000, but you also said the plaintiff was 50% at fault for his accident, so we take the award and and split it by however much the plaintiff was negligent. So in this case, it'd be 50%. Now keep in mind, it doesn't have to be 50-50. And like I said, some cases are 100-0, but let's say it was a caution light case. One driver's going through the yellow light, the other driver's coming the other way, and there's a collision. Well, that's maybe a little bit closer to call. Maybe in that case, you found the other driver of the other car 90% at fault, and you found one of the drivers 10% at fault. As long as it adds up to 100, you just have to allocate the negligence. You'd have to compare the negligence of the parties. And in that case, if the driver was entitled to $50,000, well, you would give him $50,000, but then the judge, if this was the driver that had $50,000 in medical bills, the judge would then take 10% off that number. So that's how comparative negligence works. And I think that's the fairest way to do it. I think it's a pretty fair system. Let me tell you all about a system. Let me ask you what you think about this. Some states have what they call contributory negligence. Now listen to this. Contributory negligence, if you contribute in any way to your accident, you know how much money you get? Zero. You get $0. And here's what that means. Let's say you didn't watch my video about the 3 biggest mistakes you can make after a car accident. And let's say you were in an accident. Again, this is not in South Carolina. I just want to give you an idea of how other states do it. You didn't watch my video and you gave a recorded statement to the insurance adjuster. And let's say you got hit by a drunk driver. You and your family got hit by a drunk driver. And the insurance adjuster asks you, well, how fast were you going? And you say, I was going about 50. And the insurance adjuster then asks, well, isn't the speed limit on that road 45? And you say, yeah, maybe. The insurance adjuster says, okay, thank you. You know what you've just done? Even though it's only 5 miles over the speed limit, you know what you've just done? You have just cost yourself the entire value of your case. And here's why. Because in contributory negligence cases, even though you were hit by a drunk driver, you were still negligent in this situation because you admitted to the insurance adjuster that you were doing 50 and a 45. And let's say the jury would say in a comparative negligence case, the jury would say you're 1% at fault because you were speeding. You were negligent. Technically you were speeding, you were negligent. But in a comparative negligence state, the jury would take off 1% of the award. In a contributory negligence case, they would take your full award away because you were 1% at fault. If you, in a contributory negligence state, if you contribute to your accident in any way, shape, or form, doesn't matter how small it is, you get nothing. You get nothing. And you have to ask yourself, why are some states like that? And the answer is real simple. Insurance companies. Insurance companies spend millions and millions of dollars lobbying lawmakers to get them to write laws that help them. Because let's be 100% honest. That contributory negligence rule, that doesn't help injured people whatsoever. Doesn't help them at all. The only people it helps are insurance companies. Like I said, thankfully in South Carolina, we don't have that. We have a comparative negligence. And if you ever ask to serve on the jury, that may be one of the issues that come up. You have to compare the negligence and make your best guess as to who's at fault for the accident. And then the judge would then, if somebody was negligent, the jury would compare the negligence, then the judge would take off that amount, that percentage of award from the plaintiff. Well, I hope you learned something today. And it's the end of the video, so you know what I'm about to say. Personal injury lawyers like me are everywhere. But the thing that separates me from most personal injury lawyers is ever since I became a lawyer, one of the last things I do before a client leaves my office, I take my business card. On the back of that business card, I write down my personal cell phone number. I give it to the client and say, look, if you ever have any problems, if you ever have any questions, feel free to call or text me at any time. Shouldn't your personal injury case get that kind of personal attention? If you've been involved in a car accident, give me a call, 888-9REC9. It's a free consultation. If you don't get anything, you don't owe us anything. So give me a call at 888-9REC9, and I'll make sure your personal injury case gets the personal attention it deserves.